Most wills contain no contest clauses. What are they? Are they legally enforceable? And are they effective? Well, a no contest clause is essentially a provision in a will, sometimes also called an interim clause, that says that a beneficiary under the will forfeit what they're going to get if they challenge the will. And sometimes they're very broadly written to say anything challenging the interpretation of the will or challenging what the executor does, it will also forfeit the interest. Why are they included in almost all wills? Well, because that's what the clients want. Testators generally do not want their loved ones and beneficiaries fighting over their estate. So most drafters of wills, most estate planners will put those in their estate planning documents, their wills. Are they legally enforceable? In Texas, the answer is generally yes, but reluctantly. And what I mean by that is there are plenty of cases that say they're enforceable, but courts will find many reasons not to enforce them. And generally, that involves challenges to the executor or what the executor is doing, or lawsuits over disagreements over what a will means, what the provisions mean, filing a declaratory judgment because maybe there's a dispute over a description of the property or description of the beneficiaries. Those are generally not going to be held to violate a no contest clause. So they're strictly interpreted regards to the language and the use of the provision. Lastly, are they generally effective? In my view, no. I'm not an estate planner. I'm a litigator. I've handled these cases for nearly 15 years. I can't think of a single will that I've not challenged on behalf of a client because of a no contest clause. It's something that we always look at. And when I'm defending a will, of course, the clients always want to see if they can enforce the no contest clause. And while I'll explain to them that they're legally enforceable, I rarely come across a situation where they're effective. And the reason they're not effective is you have to make the contestant think that they have something to lose. For example, if you have an estate with one surviving parent and two children, and there's $1 million in the estate, and the will says that one of the children gets everything and the other child is cut out. Well, a no contest clause obviously isn't going to do any good if there's nothing to forfeit. Or if you leave $975,000 to one child and leave $25,000 to the other, well, that $25,000 probably isn't going to dissuade a contestant who will be in line to receive $500,000 if they win the contest. And if they have a halfway decent contest, the settlement value of the case is going to be well in excess of $25,000. And frankly, what I see most often are wills that either completely cut out a beneficiary or an heir, or leave them $10 or $5,000. That's generally about it. And so that's why it's extremely rare to see a no contest provision that is actually effective, despite the fact that clients always want them and estate planners will generally include them in their wills.